Hello, everyone. It's a pleasure to be here with you all. My name is Ralph Richard Banks. You can call me Rick. I'm a member of the faculty at Stanford Law School, and I'm pleased, honored to be with this panel to talk for this important and timely event. Our goal in this session is to explain the opinions issued by the Supreme Court justices yesterday in the case of Students for Fair Admissions. There, the Supreme Court considered challenges to the race-based affirmative action policies at Harvard University and at the University of North Carolina, Chapel Hill. Although the school's policies, when challenged, had been upheld by the lower courts, the Supreme Court struck down both programs. This ruling, although not unexpected, has attracted extraordinary attention, hence this panel. Let me emphasize at the outset here, though, that the commentary you will hear is offered in all of our personal individual capacities. We are teachers and scholars of constitutional law and education law, but none of us is speaking on behalf of Stanford Law School or on behalf of Stanford University. Again, the views that will be expressed are our own. I expect and hope that as we express those views, we will actually not all speak with one voice and will show some of the differences in opinion that can arise about this contentious issue. Now, let me introduce the panel. These are three colleagues who I'm more than delighted to be here with. The newest member of the law school community is Easha Anand. Professor Anand is the co-director of the Stanford Law School Supreme Court Litigation Clinic, which I will say is an extraordinary initiative at Stanford Law School that allows students to work on active Supreme Court cases. She's also a former law clerk to Justice Sotomayor. Next, we have Professor Michael McConnell, a former federal judge. He now teaches constitutional law, including a course on the history of the Reconstruction Amendments, which are, of course, at the heart of this case. He has also written about the original meaning of the Constitution, and in particular, the 14th Amendment. And if that weren't enough, he has argued 16 cases before the Supreme Court. Last up is Richard Thompson Ford, who in fact, by tenure, is the senior member of this panel, having joined Stanford Law School before any of us. He was just a babe then. Now he is a George E. Osborne Professor of Law and the author of many provocative books that will change the way you think about not only law, but life. Thank you all for joining us. It is a pleasure to be with you. Before I turn to the panelists, let me just provide a little bit of background to put everyone on the same level here about the decision. So what were the cases that came before this one? Here is your 1 or maybe 2 minute summary. The court first issued a ruling on the merits concerning affirmative action in the Bakke decision in 1978. In that case, Alan Bakke, who was a white engineer who actually worked near Stanford in what would later become Silicon Valley, he decided to apply to medical school at the University of California, Davis. He was denied admission once, he applied again, and he was denied admission a second time. After his second denial, he reasoned that it wouldn't make sense to apply a third time. So what he did was file a lawsuit. He challenged the law school's affirmative action admission scheme, which included a quota for students from disadvantaged racial groups. When his case reached the Supreme Court, the justices were quite divided. The ruling was splintered. There were 4 justices who would have struck down the challenged policy and ruled for Bakke on the basis of Title VI, a federal statutory provision that is part of the Civil Rights Act of 1964. A different group of 4 justices would have upheld the affirmative action policy because it was, in short, an effort to undermine the racial hierarchy in society. Each of these groups of justices, the conservative contingent who would have struck down the practice of affirmative action under Title VI, and the liberal contingent who would have upheld it under the Constitution, saw this as a really clear case, I think it's fair to say. But of course, the Supreme Court has 9 members, and it takes 5 to win a case. In the middle sat Justice Powell. Justice Powell voted with the 4 justices who voted to strike down the Davis program. He was especially bothered by the fact that it embodied a quota. Yet he voted with the other four justices, the liberal contingent, to provide some basis for affirmative action more generally. Justice Powell said that race-based affirmative action should be permissible if, and I underline the if it is in pursuit of the educational benefits of diversity, and if the program is structured properly. And by structured properly, he meant, in short, that it doesn't rely on a quota, that it doesn't operate mechanically, that it does employ the sort of holistic consideration of individual applicants that we are all accustomed to, if not from our own college experiences, from those of our children. 25 years after Bakke, the court took up two challenges to affirmative action. These challenges were at the University of Michigan, at its law school and at its undergraduate school. There, the court, and there was a great deal of concern about these cases because no one knew what the court would do. After all, Powell alone had authored the opinion upholding diversity as a sufficient rationale for affirmative action. And Powell alone had described the holistic admissions process that was a necessary means of implementing affirmative action. So there was uncertainty. The court of the Michigan cases, in essence, embraced Powell's opinion in Bakke. It upheld the law school admission scheme because it adhered to Powell's formulation, both in terms of its pursuit of diversity and more or less how the program was structured. And the court also struck down the undergraduate admissions program at the University of Michigan because it operated mechanically, contrary to the spirit that Powell had expressed in Bakke. At the center of these cases, I should note here, was a different justice, our graduate, Justice Sandra Day O'Connor. She was the swing vote in the University of Michigan cases, voting to strike down the undergraduate program, voting to uphold the law school program. That 5-4 decision issued in 2003, which does seem not that long ago, in 2003 has provided the basis or the framework to which universities have looked as they have crafted admissions policies. It has also been a reference point for litigants in subsequent cases as they argued about the propriety and the constitutionality of race-based affirmative action. So that's all your background. Now let's turn to Professor Anand, who can provide us an overview of this case, Students for Fair Admissions. What did the court hold? How does Justice Roberts justify striking down these affirmative action policies that had been upheld by the lower court? I hand off the baton.
Well, thank you so much, Rick, for that really thoughtful setup. And thank you all for being part of this conversation. I think it's really heartening that so many members of the Stanford community are interested in learning about this opinion and thinking about our path forward. So I'll dig into the majority opinion with the following two caveats. The first being, there's a lot of writing. The court dropped 200 pages on us yesterday, so I'm only starting to digest this. These are just preliminary thoughts. And second, I'm going to try to do my sort of just the facts, ma'am, laying out of what the chief said, because I think we'll have a lot of time to kind of digest the implications. So I think there are kind of three parts to the opinion that I'll sketch out briefly. So first, there's the chief's survey of history. So the rule that the chief derives from the kind of brutal history of Reconstruction and Jim Crow is, quote, the inherent folly of trying to derive equality from inequality. That is, to his mind, the lesson we learn from that era is there can be no separate but equal, because treating the races differently inherently means inequality. And so he says that the core of Brown versus Board of Education, the seminal Supreme Court case saying, sort of interring the doctrine of separate but equal, is, quote, eliminating racial discrimination means eliminating all of it. Now we'll see when we get to the dissenting opinions, that's not the only way to read Brown, but that's kind of the first piece of the puzzle that the chief puts in place. So the chief next kind of runs through the doctrine and explains why Harvard's and UNC's admissions programs kind of fail the relevant legal test. So he says, first, these programs fail what's called strict scrutiny. So what does that mean? Well, when you have a program that considers race in some way, it can only survive, that is, it's only consistent with the Equal Protection Clause, if it is pursuing a compelling government interest. So as Rick explained, Justice Powell thought the educational benefits of diversity was such an interest, and if it's narrowly tailored. And so again, as Rick explained, Justice Powell thought, not relying on a quota, acting holistically, that would suffice for narrow tailoring. But the chief says, no one has been able to tell me how to measure this supposed compelling interest in the educational benefits of diversity. And in any case, I see no connection between that goal and the means employed. So that's reason one, these programs fail. The second reason he says is, we know from our case law, you cannot use race as a, quote, stereotype or a negative. And here he basically says, look, college admissions are zero sum. A plus for one person means a minus for another. You're using race as a negative here. And third, he says, the doctrine has made clear there must be an endpoint to the consideration of race. This is drawn largely from the writing that Justice O'Connor produced in the Grutter case that Rick mentioned, where she says, quote, it has been 25 years since Justice Powell first approved affirmative action. We expect that 25 years from now, the use of racial preferences will no longer be as necessary. And again, when we get to the dissents, we'll talk about whether that was just a rhetorical flourish or an actual kind of doctrinal line in the sand. But the chief says that was a doctrinal line in the sand. We know from the doctrine there has to be some endpoint, and Harvard and UNC have not been able to articulate when that endpoint will be. So that's another reason these programs fail. So he's gone through his history. He goes through the doctrine. And then he sort of ends with a kind of nothing in this opinion should be read, right? So he says, nothing in this opinion should be construed as prohibiting universities from considering an applicant's discussion of how race affected his or her life, be it through discrimination, inspiration, or otherwise. But he also makes clear that the essay can't sort of play what he calls a stealth role in undermining the opinion. That is, it can't just be about telegraphing race in another way. So, I think we're going to talk about this a lot once we sort of run through the opinions. That's sort of where the rubber is going to meet the road, right? Is what does that mean? What does that allow universities to do? And how much does it require universities to change the framework they've been adhering to since the days of Grutter and Bakke? A lot more I could say. Would actually commend you all to read this for yourselves, agree or vehemently disagree. This is an issue that the chief has thought about for more than a generation, and he has a very fully formed theory of how the Equal Protection Clause works. And so this summary is just kind of skimming the surface, but I'll stop there so that we can kind of run through the rest of the pieces of this 200 pages of writings.
Yeah, so now just to underscore that, one measure of how divisive this case was is that there were, I believe, 5 different opinions, right? There were a majority opinion by Justice Roberts, there were 2 concurring opinions by Justice Gorsuch and Kavanaugh, and then there were 2 dissenting opinions by Justices Sotomayor and Justice Jackson. So now just to cover the opinions, let's turn to Professor Ford. Could you give us some perspective on Justice Gorsuch, who spends a lot of time, in his opinion, talking about Title VI, which is a federal statute, and it might leave people scratching their head thinking, I thought this was a constitutional case.
Right. Well, in fact, it's both a constitutional case and a case involving Title VI of the Civil Rights Act of 1964. And the background here is that, of course, the Equal Protection Clause of the 14th Amendment requires or applies to state action. The University of North Carolina is a state actor. The Harvard University is not. And so for the provisions to apply to private universities, they apply through Title VI of the Civil Rights Act, which states that no person in the United States shall, on the ground of race, color, or national origin, be excluded from participation in or denied the benefits of or subjected to discrimination under any program or activity receiving federal financial assistance. Harvard University, of course, receives a great deal of federal financial assistance, as do really all selected universities in the United States, private universities, and so they're covered under Title VI. Now, the question is, does Title VI say the same thing as the Equal Protection Clause? The answer to that question has been yes for roughly 40 plus years. after the Bakke decision. So in the Bakke decision, the opinion of Lewis Powell that Rick has already begun to talk about, one of the opinions expressed was that the provisions of Title VI of the Civil Rights Act of 1964 were coterminous with the provisions of the Equal Protection Clause for purposes of higher education. And so as a consequence, there are not two separate analyses necessary. There's one analysis. The equal protection analysis just effectively applies to private universities through Title VI. Interestingly, Chief Justice Roberts doesn't talk about Title VI in his opinion for the majority, but the concurrences have this interesting kind of tag team quality that I think is a bit unusual in Supreme Court opinions, where Justice Gorsuch and also Justice Kavanaugh's concurring opinions kind of pick up pieces that Justice Roberts' opinion doesn't take up, and so they're kind of complementary. And this is especially true with respect to Justice Gorsuch's opinion, which takes up the Title VI analysis. Now, Justice Gorsuch does something very interesting here, though, because he could have just said, well, we've long held that Title VI is coterminous with the Equal Protection Clause. It is here too. Therefore, this applies to Harvard. I'm done. A very, very short opinion. But instead, he says, he questions the long-standing position that Title VI should be understood to be coterminous with the Equal Protection Clause, and instead says, look, Title VI is a federal statute that should be interpreted in its own right, and the way I, Neil Gorsuch, interpret federal statutes is through a method called textualism. We should read the text of the statute and interpret it according to what he calls the ordinary public meaning that those words have. So he starts by looking to the dictionary, and he's done this in other cases too, one that I'll talk about in a moment that's important for this analysis. But he looks to the dictionary and says, well, what do these words mean? And the dictionary gives us a definition, and that definition makes it clear, according to Justice Gorsuch, that Title VI prohibits any use of race. So this is the ordinary public meaning of the language that Congress adopted in Title VI. And so we don't, and he suggested it was a big mistake to lump this together with equal protection analysis, which has a different language and a different jurisprudential history. We've got a really straightforward statute where, at least according to Justice Gorsuch, the meaning is quite obvious. It's clear that this prohibits the use of race. Affirmative action is the consideration of race. Simple. Now, he goes on to say, and this is a little twist that's somewhat interesting. He says, you know, a lot of people are pushing back against this in a variety of ways. They're saying Title VI doesn't really mean what I say the ordinary public meaning is. Lots of questions about ordinary public meaning that we can talk about later, but one thing that he zeroes in on is a case that he decided earlier, Bostock versus Clayton County. And Bostock versus Clayton County, in analyzing Title VII of the Civil Rights Act of 1964, Justice Gorsuch applied, once again, his textualist methodology to determine that the prohibition of sex discrimination, one to be discriminated against because of sex, necessarily meant that Title VII prohibited discrimination against gay and transgender employees. And he came to that conclusion by using a similar methodology. Just let's look at what the text says, not worried about what Congress intended. That's a speculation that we don't need. It's not necessary to interpret a statute. Here's what Congress passed. Here's the language. It says discrimination because of sex is unlawful. There's no way of considering the sexual orientation or the gender identity of an individual without also considering their sex. Therefore, QED, we're done. And this opinion would anger many conservatives who felt, well, Title VII, when Congress passed Title VII, they didn't intend that. It's very clear they didn't intend this to extend to transgender individuals. Neil Gorsuch says that doesn't matter. I'm looking at the text of the statute. This is what Congress passed. Now, in this case, he then says, well, Title VI and Title VII, they're right next to each other in the same statute. They have almost identical language. They mean the same thing. In Bostock, I said it didn't matter. There's just, it's a straightforward analysis, prohibits the use of sex in employment decisions. In Title VI, it prohibits the use of race in the decisions of institutions taking federal funding. And he kind of sticks it to the liberals and says, either you disagree with Bostock, and it seems that many of you embraced it at the time, or you need to accept my analysis in this case. There's no room for you to break apart the analysis of Title VI and Title VII because the language is so closely identical. So it was an interesting opinion, and one that raises some questions about past jurisprudence about the use of textualism as a matter of statutory interpretation, and suggests a new way of understanding the meaning of Title VI is distinct from the Equal Protection Clause, and that is a new innovation. Now, this is one opinion. It's just Neil Gorsuch, but nevertheless, it's Neil Gorsuch and Clarence Thomas because he joined the concurrence, but two justices. But nevertheless, it opens up something quite interesting, I think, with respect to the civil rights issues moving forward.
Thank you so much. Now, I should admit, I'm feeling a bit embarrassed now because I think I said there were 5 opinions in this case. Correction, there were 6 opinions in this case. I overlooked Justice Thomas's concurrence. Please don't read anything into that. Justice Thomas spent a great deal of time in his concurrence on the issue of history and trying to probe the original meaning or the original understanding of the Equal Protection Clause. We turn now to our own Professor Michael McConnell to discuss Thomas's exploration of history and the basis for his conclusion that the Equal Protection Clause mandates a norm of colorblindness.
Yeah, so I think these separate opinions really are interesting and that they do supplement each other, as you said earlier, Rick. The Chief Justice's opinion primarily relies upon precedent. I mean, not exclusively, but primarily is rested on precedent, and essentially says we meant what we said about strict scrutiny, but this time we're really going to hold the school's feet to the fire. And so it's about what strict scrutiny requires, and in particularly narrow tailoring. Well, Clarence Thomas joined that opinion, so he doesn't disagree with that, but he adds to that an argument based upon the history of the 14th Amendment, and particularly the Equal Protection Clause. And I'll just give a brief summary of his analysis there. So there were 3 amendments passed to the Constitution related to the end of slavery and the inauguration of a more equality of rights regime at the end of the Civil War. The 13th Amendment abolished slavery and empowered Congress to enforce that, not just against state action, but altogether. So slavery is the end of slavery is actually the only provision of the Constitution that applies directly to individuals. Any of us could enslave in theory, right? Even though we don't have any governmental power. So Congress is empowered to end slavery, not just by ending laws that supported slavery, but actually ending the social and economic situation of slavery. Almost immediately after the passage of the 13th Amendment, there was considerable disagreement about how far it went, and the larger group in Congress took the view that there were a number of things that fall considerably short of actual, like, physical enslavement that are badges and incidents of slavery. So they passed something called the Civil Rights Act of 1866, which guaranteed that all citizens without regard to race, color, or previous condition of servitude, would have the, quote, same rights as white citizens. And then they list what those basic rights are: the rights to enter into contracts, or hold property, benefit from the laws of personal security, and so forth. And so the 66 Act was expressly race conscious in the sense that it addresses race, but it was also expressly colorblind in that it provides that everyone, all citizens, without regard to race or color or previous condition of servitude, have the same rights with respect to that. Well, President Johnson, the accidental president after the assassination of Lincoln, vetoed the 66 Act on constitutional grounds. It was passed over his veto, but there were a number of figures who were prominent in the civil rights movement of the day who thought that actually President Johnson had a point, and leading among these was John Bingham, a congressman from Ohio, who is the principal drafter of the 14th Amendment, and who believed that he totally supported the Civil Rights Act of 66, but believed that it went beyond Congress's powers to end slavery because it was essentially abolishing racial discrimination in general, which was, in Bingham's view and the view of others in that camp, more than the 13th Amendment provided for. And so Bingham then becomes the leading drafter of the 14th Amendment. Now, Justice Thomas goes into much more detail than this. There are actually two competing drafts of the 14th Amendment, one written by Thaddeus Stevens, probably the most radical of the radical Republicans, which was an express prohibition on racial discrimination. Probably would have resolved these cases on their own language, at least if one goes with Gorsuch and says that words mean what they say. And then the competing draft by Bingham, which was adopted, provides that all citizens, no state may deny to any citizen the privileges and immunities of citizens of the United States, and that no state may deny to any person, whether a citizen or not, any person, the equal protection of the laws. There is no mention of race. Also, no mention of, what does that apply to? Much of the debate after that has to do with its application to women, as opposed to just its application to race. But so Thomas argues that that when you see the purpose of the 14th Amendment to constitutionalize the 1866 Act, and then you see the language used in that amendment, it is a prohibition of all kinds of racial discrimination, basically of all types. And he quotes a number of leading figures, not just Bingham, but Senator Howard, who introduced the amendment on the floor of the Senate, and a number of others who use language that either includes the word colorblind or has essentially the same meaning as that. And so he concludes from this that the ideal of the 14th Amendment, and especially the Equal Protection Clause, is that the law is the same for black and white, and that you can't that it's illegitimate under the 14th Amendment to sort of turn it around and make it a special protection for formally subordinated classes.
Thank you so much, Michael. And we should note here, just to put a pin in this issue as in others, is that these interpretations of the opinions of the justices, or the interpretations that the justices in the majority have offered, they were very contested by the dissenters, right? Justice Sotomayor, to say the least, disagrees with Justice Thomas's interpretation. So we're going to come back to that. But first, let's go to another issue where Justice Sotomayor disagreed very vigorously with Chief Justice Roberts, and that's with respect to the issue of stare decisis, right? And as a layperson coming to this, you might wonder, is this a continuation of the law or is this an overturning of the law? Was this a change? If this was a big change, which it seems to be, how was that change justified? What was the basis for the change? Professor Anand, we look to you for that analysis.
Sure. And like you said, Rick, there's so much in this dissent that Justice Sotomayor writes, that including a kind of a countervailing story of history, a story of history that's focused specifically on the denial of education and how that's linked to racial subordination in this country. So read the dissent, but on this stare decisis point. So you'll recall the majority, right, gives these kind of three doctrinal reasons. They say benefits of diversity for education can't be measured. College admissions are zero sum, so using race as a plus inevitably means using race as a minus for somebody else, and there must be an endpoint. And Justice Sotomayor's dissent says, look, all of this was true in past cases too. The educational benefits of diversity were no more measurable or quantifiable 20 years ago or 50 years ago than they are today. College admissions were no less zero sum 20 or 50 years ago than they were today. And colleges in cases like Bakke and Grutter articulated no firmer endpoint than did Harvard and UNC today. So her take, and this is, for whatever it's worth, it's shared by Justice Thomas, who also says, we're not saying it, but Grutter has basically just been overruled. Her take is, look, every argument you've leveled at these two programs is an argument that did not carry the day in one of these prior cases. And we know this because she quotes from dissents in Bakke and Grutter. She says the dissents made this argument, not the majority in those cases. The chief doesn't meaningfully rebut that point, but he says two things that I think are kind of important on this stare decisis front, right? The first thing is he says, look, stare decisis has its greatest force where there's a kind of reliance interest, that is, where people have made decisions based on our prior cases. And here, we have told you from the beginning that affirmative action was not a forever thing. This court has always said that affirmative action is a time-limited thing that at some point will sunset. And so it wouldn't have made sense to have these sorts of reliance interests on our past precedent. You can't come here in good faith, Harvard and UNC, and say, we thought we were going to be able to do this forever, because we kind of told you that you weren't going to be able to do this forever. And the second response that the chief has to Justice Sotomayor's dissent, I think kind of reading between the lines, and this picks up on something, Rick, you've talked about publicly before. The world does look very different than it did when Bakke was decided, right? Students who were seeking admission in the 1970s had grown up under the era of Jim Crow. And so to the extent he's sort of tweaking his test, there's sort of hints in his opinion that sort of says, look, one of you said that we're going to hold universities' feet to the fire more now. And I think that what he's essentially saying is, look, societal conditions have changed sufficiently that it makes sense to apply this test that he claims we've always articulated in this more kind of forceful way. So to summarize the difference, the majority says, we're not overruling anything. We're just applying the text of these prior opinions. But Justice Sotomayor in dissent says, look, Justice Thomas is right when he said his concurrence. You are doing some overruling here. And the way I can prove that is every single argument that you are making in the majority for why these programs fail was an argument that dissenters made in Grutter and Bakke, and the majority did not adopt.
On this question of sunset, that brings to mind Justice Kavanaugh, who spends a fair bit of time discussing what he terms the, quote, 25-year limit on affirmative action, as though the clock was ticking from 2003, and now time is about to run out. Professor McConnell, would you offer a little perspective? Was there a 25-year limit on affirmative action, or?
Well, I should, if you're interested in my view, one of the
Please.
One of the two places where I was most persuaded by the dissenters is that this makes no sense. But Kavanaugh does persuade me that the court referred to some kind of a time limit more often than I had realized. What I think Kavanaugh is doing in general I don't really think that's his total focus. I think in general, what he's trying to do is shore up the Chief Justice's argument that the majority is actually based upon past decisions and is consistent with precedent rather than breaking from it. And he does that by going through and bringing back a number of quotations from majority opinions in the past. And in a sense, I think both sides have very strong arguments here in that what the past decisions did was do a lot of saying one thing and doing another. They really are not very consistent. And so, yes, it is true that in cases like Bakke and Grutter, that they suffered from many of the same defects that the UNC and Harvard plans do today. That's true. But of course, the plan in Bakke was struck down. It wasn't upheld. It was held unconstitutional. The plan and the undergraduate plan in University of Michigan was struck down. And even the plans that were upheld with the argument that strict scrutiny applies, and yet at the same time the court didn't really. I think it's fair to say, from an objective point of view, the court didn't really apply strict scrutiny in its usual form. It deferred very heavily to the judgments of the defendants in these cases, and so when you look back on it, what is stare decisis looking to? Is it looking to strict scrutiny? And in that case, these decisions actually are quite true to the past, or is it looking to the fact that some individual programs in the past had been upheld, in which case it's the dissenters who have the better argument on stare decisis. Now, as to this cutoff point, I mean, you asked me my opinion about it. You can see the court has been warning about this for a long time, but I don't understand where it comes from. I think the basic problem with the plans is that the means used, when you actually look at how the programs operate, that they actually are not at all close to serving the purposes stated. That is, they benefit people who did not particularly suffer past discrimination. The burden falls primarily on Asians and Jews who certainly did suffer past discrimination, and then there's all this sort of miscellaneous stuff like, why would it be that a descendant of German immigrants to Argentina then come to the United States and they're privileged, whereas if they had come directly without the stopover in Argentina, they wouldn't be. I mean, what sense does any of this make? And if it's diversity, why are we not paying attention to other forms of diversity? Like, for example, how about Islamic students? How about people of Middle Eastern background? Isn't that just as important to the things that go on in discussion in the classroom as anything else? So that the ends means connection between how these programs actually work, I think that's the real problem that the court is talking about. And if they solve that is, if they had programs that actually did target people who suffered past discrimination and who would bring diversity to the classroom and so forth, then I don't see any speaking for myself, I don't see any reason why those would go away. Those would seem to be sensible grounds for admissions committees to consider always. Just as I mean, when we say that they ought to, most Harvard, I think, has some special rules for like people over fly-in country, people from Nebraska, right? To make sure that we don't have nothing but a bi-coastal student body. Well, the idea that we ought to have more people from Nebraska is not going to sunset in 10 years. It's just part of the idea of having a diverse student body. So it's at least my personal opinion is that this is the least persuasive aspect of the majority opinion, but it is as Kavanaugh says, it is rooted in things that they've said in the past.
So, Michael, you've given us enough material here for the next 3 panels. So there's a lot to work with here. Let's try to unfold it. So just to provocatively state what I think I heard from you about this court's prior decisions is that there has been a thread of hypocrisy that has connected these decisions one after another, where the court says one thing and does another. It says it's applying strict scrutiny and looking stringently at practices, but then it defers to the university at the same moment and allows practices that, on a stringent view, certainly wouldn't hold up. And if that's true, one way to look at this case is that it's actually getting rid of the hypocrisy, and it's resolving or eliminating the gap between the words and the practice of the court. Is that an accurate interpretation? Easha and Rich or Michael, is that a fair understanding of this opinion?
Well, no, I don't think so. But there are a few complexities. It's certainly true, as Michael says, that the past affirmative action jurisprudence has been somewhat ambiguous. And one of the reasons for that is that you started with the diversity rationale that was the opinion of one justice, Lewis Powell, but that then became the exclusive rationale for affirmative action, and everyone converged around it. I think in reality, reasons for affirmative action include diversity, but also other things like a remedial rationale that focuses on the prevalence of systemic discrimination affecting members of minority groups. But that rationale couldn't be clearly articulated. So there is some truth in the idea that the past decisions were somewhat muddled and ambiguous. But at the same time, this opinion has some duplicity of its own. And one thing I would point out is that the obsessive focus on individualism as so in the end of the majority opinion, Justice Roberts says, you can talk about race, but it's got to be about this individual, not a group. And he spends a lot of time, as does Justice Kavanaugh and Justice Gorsuch, talking about the imprecision of the racial categories. Now, all of that's true, and yet what it doesn't take account of is that the standard best practice for trying to correct for patterns of discrimination and bias that are hard to identify, hard to prove, subconscious bias, systemic bias, and what have you, is to look at statistical outcomes and to check your process against some statistical benchmark that you would expect a non-biased process to generate. And it seems to be that that's what the universities were doing. Now, no, those categories are not perfect. They can't be. Race is a social construct. It's not a biological essence. And so the categories are imprecise, but they're close enough to tracking the kinds of systemic disadvantages that exist in our society that it's sensible for the universities to use them. Now, I'm not saying that the current admissions policies that were challenged were perfect by any stretch of the imagination, but they were sensible attempts to try to deal with these questions of systemic prejudice, and you just can't get at those by looking at individual cases alone.
So just to pick up on one thread that Rich articulated, I alluded earlier to this kind of sentence at the end of the chief's opinion. Michael picked up on it and talking about Kavanaugh's concurrence, where he says, nothing should be construed as prohibiting universities from considering an applicant's discussion of how race affected his or her life. So here's why I think that line actually doesn't do that much for those of us who do think that race-based affirmative action is vital, right? So the first is the point that Rich just made, which is that even if when looking at an individual application, admissions officers can consider how race affected that applicant's life, the opinion, pretty clearly forecloses the kind of back-end thing that admissions officers always do, right? So the admissions process, there's always a point where you've kind of admitted the class you think you're going to admit, and you take a look and you say, do we have too many oboe players, not enough STEM majors, right? Too many New Yorkers and not enough Nebraskans, a deficit of drama kids, whatever. They're looking not only for the best applicants, but kind of what kind of class are we admitting taken as a whole? And the one thing that admissions officers can't do at that point, that Rich was spelling out, is, say this is going to result in a class that's far wider than in previous years, for instance. And that, I think, removes a critical tool from admissions officers' arsenals. The second reason I think that sentence maybe provides some cold comfort is I think the line between giving special consideration to an application because of the race of the applicant and giving special consideration to an application because the applicant faced hardship that is inextricably intertwined with race is actually fairly razor thin, right? The distinction the chief is trying to draw between those two things will kind of inevitably invite more litigation. And I think that's particularly so because the thing the chief says is allowed, right, considering how race affected an applicant's life, sounds pretty close to what the district court found that at least UNC was already doing, right? Justice Jackson quotes this in her dissent. UNC has this, quote, personalized assessment of the advantages that every applicant might have received by accident of birth, plus all that has happened to them since. And so I think this puts colleges in a little bit of a bind, right? Either their racial diversity plummets, or if their student bodies remain diverse, they'll be accused of using essays to stealth do kind of what the court said they couldn't. So that's the second reason, is I think that this distinction that the chief is trying to draw will invariably invite more litigation. The third thing I just want to put on the table is perhaps the most controversial, but I'll sort of stake a position on this. There's a reason why we want sort of so-called objective proxies in the admissions process. We use the SAT not because we think it's perfect, it's radically over and under inclusive, but because we think it's valuable to have some parts of the admissions process that are not just based on the kind of subjective judgment of the admissions officers. And I worry that the same is kind of true here, right? So by moving to a system that relies on a description of how race affected a candidate's life, you're inevitably moving to one where first, you're inviting gamesmanship, right? People will be coached on how to package their race. And second, where you will inevitably admit those applicants whose stories about their relationship to their race reflect whatever biases admissions officers have. And again, we all have perceptions and biases. This is not a knock on admissions officers who have a hard job that they do with great integrity. And I suppose, ironically, I worry that in trying to kind of root out some of these stereotypes, the Supreme Court may, in fact, be creating an admissions scheme that doubles down on those, right? So in a world where someone's race, full stop, might result in special consideration or another look at their application, someone who thinks that their race was actually entirely incidental to their life and someone who thinks their race was central to their lived experience both get whatever that special consideration looks like. But in a world where we're relying on race mediated through essays, I worry only those students who package their race as central to their identity in a way that's sort of legible to admissions officers will get whatever bump we're talking about. And that'll result in fundamentally, I think, a sadly more homogeneous class.
This is fabulous. So you've highlighted that what I think is a contradiction here, if I'm reading this correctly, that the majority, Justice Roberts suggests that he wants to diminish the salience of race, and his approach to admission is intended to do that. But by allowing students to talk about race in their application essays, which they certainly will do, and they'll have very powerful incentives to do so in ways that they think will help them in this process, and universities will have every incentive to elicit that information, it actually may make race more salient in people's minds and even in their lives as they tell themselves stories about the centrality of race in their life and how they have to package that for an admissions audience. Michael.
I think that is absolutely right, and I agree with Easha's normative judgment on this. It's just that this was what was unlocked way back when they decided not to use quotas and instead use a so-called holistic system that introduced all the subjectivity, and I think and brought the gamesmanship. those essays are, in my judgment, it is truly a mess. I actually think we would be better off as institutions not to look at the essays. I think the essays are what we know about the process is that wealthy people hire consultants to help their kids write the most effective essay. And that means, to the extent that universities, value the essays, we're actually doing something extremely perverse. We're not, but the other, and so I don't like this. I don't like the emphasis on the essays, but look at it this way. What does the admissions office do when they're confronted with someone who fits the racial category, but the parents were like doctors and lawyers or successful, but and they went to the Dalton school or some other fancy school, and they look just like their white peers, except that they don't, except for the color of their skin. They come from the same privileged backgrounds. Do the admissions committees actually say, oh, that person is not deserving of any special boost? I don't think they do, because what I think universities want is a picture of their class that has a certain number of Black faces. And I don't think they care whether the Black faces are there because they're privileged or whether they're there for some other reason. I think it is race and race alone. And to the extent that this majority opinion is telling them, no, it has to actually relate to the reasons why race is a legitimate consideration. I think that's all to the better. Now, that may not mean looking at the essays, but it may mean looking at some other things.
Okay, this raises Justice Jackson's opinion. Justice Jackson, one of the newer members of the court, wrote in dissent. And one of the issues that she emphasized throughout her opinion was the salience of race in American society, right? That there continue to be broad disparities between Blacks and whites, for example, with respect to wealth, health, well-being, employment, income, education, all sorts of outcomes related to what we might think of as the good life. And one question this raises, and Michael, your example raises this, is whether we should think of race, the significance of race, as being reduced to socioeconomic status, so that the Black student who went to Dalton and applies to the school, that they're kind of comparable to their white classmates? Or is there something more to race other than the socioeconomic disadvantages that we might associate with it? And then the second question is, how do we respond to that, right? And she and Chief Justice Roberts, of course, have very different responses to the salience of race in American society. Rich, I'm feeling this would be this is right up your alley.
I am happy to speak to this because I do think that race is a distinctive and long-standing social category in the United States that, as we all know, has been the basis of systematic, organized, state-sponsored hierarchy, and the racial attitudes that were responsible for that have not gone away entirely. Indeed, they're quite pervasive. Often they're concealed in today's environment, and sometimes they're subconscious, but they have an effect on day-to-day decisions. So let's take the kid who's going to the Dalton school. I mean, I would say that that's the hardest case. Michael's right to say that's the hardest case for affirmative action. And I think it's a fairly small number of applicants that fit into that category. But even in that context, an African-American who's going to all predominantly white schools, circulating in predominantly white environments, is, I would argue, overwhelmingly likely to have encountered some form of subconscious or concealed bias that would have affected them in some way. Now, they may not know exactly where. I can speak a little bit from experience. I didn't go to the Dalton school. I went to a public high school in rural California in the 1970s and 1980s. And my parents were educated, and they were educators, and they were well positioned in the community. But I'm certain that I encountered some teachers who were somewhat racially biased, who treated me less well because of stereotypes, whether they were aware of that or not, and that the attitudes, the psychological toll that takes, as well as just objective effect on grades, makes a difference. Now, I couldn't prove it in any particular case. And I could have written a college admissions essay talking about it, but for reasons that I think are somewhat sound, psychologically, that wasn't something I wanted to dwell on. And so instead I was taught to move on. You don't focus on that. You keep your head down and do your work. I think that's probably a more healthy attitude, but that doesn't mean that the prejudice isn't out there and it's not having an effect. Again, we can't be sure in every individual case. Michael might be right that there's a kid that went to Dalton and lived a privileged life with a silver spoon in their mouth, and race had no effect on them. But I would argue that is a vanishingly small number of African Americans in this society, even today.
Okay, so this discussion is about the sort of the beneficiaries of affirmative action, right? And one issue is how much has that beneficiary group changed over the past 40 years, right, since Bakke? How much are the disadvantages of the past still with us? Now let's look at the groups that are burdened by this by affirmative action policies. One striking feature of this case, Students for Fair Admission, is that the plaintiffs were different in a distinctive way than the plaintiffs in almost every other case. In the other affirmative action cases that have reached the Supreme Court, the plaintiffs have almost always been white Americans, and they claim they were discriminated against. That created a certain moral calculus in the case because you have kind of paradigmatically, African Americans on the beneficiary side, the group that the universities are trying to help, and then you have white people on the burden side, sort of representative of the dominant group in society. And that likely underscored or sustained some of the support for affirmative action. But in this case, the architect of the cases, Edward Bloom, made what I think is really a brilliant tactical or strategic decision, frankly, which is that he brought Asian American plaintiffs into the case and made them the focus. So Rich, or Easha, either, or actually any of you, how does the fact that the plaintiffs in this case were Asian American, how does that matter, or does it matter to the equities of the case?
Well, I'll jump in. It certainly matters to the optics of the case and to the public perception of the case, and that's important because, as you say, Asian Americans have suffered long-standing discrimination in this country as well, and so the moral narrative looks more complicated when it's Asian American plaintiffs who are challenging affirmative action. Another thing that the fact that the plaintiffs were Asian has done is it's created a number of distinct legal issues that were not salient in past affirmative action cases and have gotten glommed together. So when you look at the way this case proceeded at the trial court, the Asian American applicants were suing for discrimination, a straightforward discrimination case. There are a lot of ways that Harvard might discriminate or the University of North Carolina might discriminate against Asian American applicants that don't involve affirmative action. So they might apply their subjective criteria along things like likability and citizenship in a discriminatory fashion. That's one. You might argue, and certainly when you look at the statistical disparities, much of the statistical disparities are due to things like legacy preferences and athletic preferences and geographic preferences. So all of this is in the mix at various points when people are assessing the strength of the case. Not all of it's legally relevant because, of course, there's no disparate impact cause of action under Title VI or the Equal Protection Clause. And so the legacy preferences and the athletic preferences and all those things, actually aren't subject to legal challenge as discriminatory. But a discriminatory application of subjective criteria would be subject to legal challenge. These are all lumped together with affirmative action. Now, and so in the minds of the public, that's all in the mix. As a legal matter, the trial court, of course, resolved all of this. it found that the universities did not discriminate. So that as a legal matter should drop out of the case. But when you read the majority opinion and some of the concurrences, it bubbles back up in terms of, for instance, a focus on the statistical disparity between the number of Asian Americans that would be admitted if you only looked at grades and test scores and the number actually admitted. Most of that disparity is due to stuff that's not subject to legal challenge, but it still makes the entire admissions process look bad. And so there was a lot of that went on. I think you're right to say that bringing the way these cases were brought up, the posture in which they were brought up was a quite clever strategy, because it did allow for the litigation to focus on some of the weakest and most objectionable aspects of university admissions, even not affirmative action, but other aspects of the admissions process that aren't subject to legal challenge, but will make people unhappy and make the universities look bad.
Okay. Let's, you mentioned the issue of, or alluded to legacies and athletic recruitment, which featured prominently in the Harvard case in particular, because Harvard, like many elite schools, has a fairly high proportion of students in the student body who are legacy applicants, meaning their parents or their family members went to the school, or who are recruited athletes. I believe in the Harvard litigation, it came out that up to as many as 43% of the white students who enrolled at the school actually were either recruited athletes or legacy admits, or through a related special category. Justice Sotomayor focuses a lot on these facts, and her view, again, to state it provocatively, seems to me that she's saying that the Supreme Court is striking down affirmative action, but they're allowing, and the plaintiffs are not really challenging the legacy admissions practices or the athletic recruitment practices, even though legacy admissions was clearly developed out of racial animus as an effort to keep Jews out of elite universities about a century ago, right? And so, there's a clear racial background there at least. But Justice Sotomayor seems to say that what the majority is doing is eliminating affirmative action for Black and brown people, but leaving it in place for white people. Mm-hmm. Is that a misreading of her opinion? She doesn't put it quite so starkly.
Mm-hmm.
I do think that the sort of legacy and athletic preferences are doing a lot of work, both for the dissenters and for the majority. So I agree with you that Justice Sotomayor is troubled by this idea that you can give tips for all sorts of things that are correlated fundamentally with generational wealth and therefore correlated with whiteness. I think that the sort of shadow of legacy and athletes is also hovering over the majority, right? I think that the, Justice Gorsuch says in his concurrence, look, you can get a class that looks exactly the same in terms of racial makeup if you, one, give socioeconomically disadvantaged students half the tip you give athletes, and two, eliminate tips for children of donors, alumni, and faculty. I haven't looked at the record. I don't know if this is true, but he claims that the record supports that position, right?
That was fine until you got to the faculty part. But
yeah, that's right. None of us are on board with this. And so I do think, and this is a theme that Justice Thomas has played out in prior opinions. I do think for some of the justices in the majority, there's this idea like, look, this is a problem of your own making, right? You universities claim to want to admit a diverse class, but then you have to admit all these students who are white and wealthy because you care about athletes and legacies. And then you're reduced to doing this kind of racial balancing on the back end to make up for the fact that you've just given away half the class slots to students who wouldn't be deserving but for their whiteness and wealth. So we're not going to let you use this racial balancing on the back end to make up for your racism on the front end. I think that's there are lots of problems with that, but I do think that is the one narrative that Justice Thomas has a story Justice Thomas has told in the past, right? He sort of said in the Grutter case, look, if you really care so much about diversity, stop caring so much about standardized test scores. You get a much more diverse class. What you can't do is on the front end say, no, these things are fixed, even though they We know that they admit a disproportionately white and wealthy class, and therefore we have to use affirmative action to make up for essentially our own racism in allocating slots in the class. So I think that this kind of backdrop of Legacies and Athletes is doing a lot of work for both the majority and the dissent, but they draw starkly different conclusions from the fact that university admissions policies do prioritize these groups.
Excellent. Now, in our last 20 minutes or so, let's turn to the question that perhaps many people have been waiting for, which is what can universities do and what should they do in the aftermath of this decision? Let me begin with the provocative example that came up during the course of oral argument in the Harvard case, I believe. So now that the court has prohibited the use of race-based affirmative action, what if universities said, okay, no more race? We're going to strike that word from all of our materials and our policy manuals and everything. But what we will do is we will offer affirmative action for descendants of people enslaved in the United States. We're not looking at race. We just want some indicia of being descended from a person who was enslaved in the United States. Would that pass muster under this ruling?
Good question. It's not at all clear, is it? I mean, in oral argument, as I remember, is the justices were questioning the attorneys, and they were marching up to this example that once they got to descendants of enslaved persons, the attorneys for students for fair admission said, no, that's a proxy for race. That goes too far. That's a proxy for race. So I expect there would be litigation if a school did that, with people claiming that that is simply a proxy for Black race. But it's a pretty good question. And I don't think the majority opinion resolves it at all.
No. And let me say, and I ask because one of the striking features, right, of the majority opinion, I think, is the sort of the formality, or that there's kind of a formalism to the use of race, right? It's kind of race, as the court refers to it, which of course, as Rich alluded to earlier, it treats race as this sort of individual, simply label that attaches to people and ignores the ways in which race instead is a social creation, part of the cultural fabric, something that's woven throughout our society. Right. So it's not as though there's a sharp divide between race and not race, because, of course, you might think of the descendants of slavery characterization, or that definition, as a proxy for race. But you could also think of race as a proxy for being a descendant of slaves and all the other stuff that's associated with race-based disadvantage. Right. So
I don't know that, but I don't think that that's symmetrical. I mean, I'm not sure how they would come out, but I think preference for descendants of slaves is much easier to defend, and there are lots of people for whom their Black race is not a proxy for having been descendants of slaves, including all the numerous fairly recent immigrants from Africa, whom I understand, I don't know the numbers on this, but I understand constitute a surprisingly large subset of the Black beneficiaries of affirmative action. I also note that this would exclude, it doesn't have anything to do with migrants coming across the southern border. We have all kinds of other sort of moral questions. Why is somebody, why is a migrant from El Salvador treated in one way, but a migrant from Afghanistan not? I mean, which of those groups is more morally? Neither of them have any particular connection to America's racial history, and who is more deserving? And yet, that's the way these programs are administered. If they actually were much more tightly related to their rationales, I think it'd be harder for the Supreme Court to say that they flunk a strict scrutiny. Now, I'm not sure descendants of of slaves. It's, if you look at the closest parallel to this, the Freedmen's Bureau Act, which was part of Reconstruction, it was all about the recently freed former slaves. And although the act actually benefited both freedmen and so-called loyal refugees, which were basically white pro-union people in the South, but it excluded free persons of color from, that is, people who had been free persons of color under the prior regime. And so you are getting much closer to something that has some sort of actual historical grounding if you did that. Now, I also wonder, what about people who are also descended from slave owners? Do you deduct that? Do we, fortunately, my people came to the United States in the second potato famine, and so we're not in either of these categories. But maybe being descendants of slave owners should be deducted. A lot of people are both.
So this is wonderful. So what should universities do then? And again, we're not advising university, we're speaking in our individual capacities, but how should universities take the opportunity, if you will, that this decision creates to rethink how they select among students?
Well, I'll jump in. Something I really think they should do, instead of, whether it's instead of or in addition to what they're doing, I don't know, but probably instead of, is they should look to see whether the school that the applicant is coming from is one of these underperforming, catastrophically underperforming public schools, and any student who excels coming from those schools, I think, should get a very significant boost. And what that does is it makes the boost, the affirmative action, actually related to a deprivation that's closely related to discrimination. And the fact that they excel in that environment relates it to their own individual characteristics. So I think that would be good public policy, whether or not this decision had come out the way it did.
Okay.
Well, I would say that there are a few things that universities could do. One of them goes back to a conversation that we were having when Eisha was talking about some of the objections to legacy preferences and all of these other things. You could look at all of those as things that have a disparate impact. Now, disparate impact is a doctrine from another doctrinal area. It doesn't directly apply in the context of Title VI. But if you were looking at this in the context of employment, a standardized test with the effect that the SAT has on minority admissions would be suspect. And the universities could look at those and say, we've got things with a disparate impact. Is it justified? Are there other ways to achieve our goals that don't adopt those? That would be one. And, that does get at the legacy preferences and the, sports, particularly the kind of somewhat patrician sports that many selective schools tend to favor, like, crew and sailing and the like, that certainly benefit white applicants at the expense of both Asians and also, African Americans and Latinos. So that's one. I think some of the stuff that Michael was talking about deserves serious consideration, that the schools should not abandon a focus on some of the things that race is a proxy for, social disadvantage, experience with racism, descendants of former slaves, what have you. But no one argues that the existing affirmative action plans are perfect, that the categories are, come from the Platonic realm of perfect ideals for dealing with social disadvantage or anything else. They could be revisited and take the court seriously on its, on the proposition that you can focus on these things, provided it's not, race per se. There's some room to continue to promote the values of diversity and actually improve the process. Now, I don't want to be Pollyanna-ish about it. I think this is a bad opinion and it's going to have negative consequences. It's going to make life harder for universities to achieve their legitimate goals. But I do think there are things that people can do in contrast, in reaction to the opinion if they're not, if they don't overreact, and if they, look carefully at what the court has said they can still do as well as what they can't do.
Let's take up that question of the implications. So, which we've been talking about admissions, but what are the implications of this opinion beyond admissions and for campuses and universities? And I'm thinking about programs like DEI programs, which are common now in many universities, other diversity initiatives relating to everything from curriculum to housing to student activities. Are these programs going to be on the chopping block, so to speak, or are those insulated in some way from the logic of this opinion?
Well, I could jump into that at the risk of talking too much. For just really quickly, Justice Gorsuch's opinion on Title VI suggests that there is some appetite on this court to apply a similar logic under Title VII. And if that happens, then that does directly affect employment, for instance. And so one might then say DEI efforts in the employment context are, at least in a little bit of trouble. At the same time, in the employment context, no one engages in affirmative action that looks like what happens in higher education. I mean, the affirmative action programs are pretty sui generis in the higher ed context, so it's not obvious how this applies in other contexts. And much of the DEI efforts that involve, let's say, outreach and education are, don't seem to be covered by anything that the court said here.
I think I agree with that. And maybe I'll just say two things that kind of give me pause, right? So the first one is lurking in the backdrop of this case is the next case, right? And to me, that next case, the kind of, it may not be this case specifically, but the kind of pathway that we see opponents of affirmative action traveling come from this case against Thomas Jefferson High School, which is a high school in Virginia. It's a magnet high school. It's very selective, and for years had an admissions process that resulted in a class that had very few Black and Latinx students. A few years ago, Thomas Jefferson rejiggers its admissions process. Now, the new admissions process is entirely race neutral, right? It has criteria like which middle school you went to and how you were ranked within that middle school, sort of similar to a top 10% plan. It puts more weight on recommendation and less on the standardized test. But the challengers say, it may be that the process you ultimately adopted was race neutral, but you were motivated from the start by the desire to increase the number of Black students and reduce the number of Asian students. And that sort of insidious motive has tainted this whole process. Now, this is very schematic, that the case is actually much more complex than I'm letting on. What makes me nervous, right, is that case, when it came to the court and the court sort of asked us to intervene before the judgment is final, three of the justices, Justice Alito, Thomas, and Gorsuch, would have intervened at that point on the side of the challengers. Now, I don't know that they have 5 votes for this theory. And in fact, one of the heartening things about Justice Kavanaugh's concurrence is I sort of take him to pretty clearly be saying, I don't buy that, right? I think he specifically says you can act to undo the effects of discrimination in many permissible ways that do not involve classification by race. So I take him to be kind of staking his position, which is that I don't buy the Thomas Jefferson theory. I don't buy that efforts to increase diversity, even if through race neutral measures, are verboten under the Equal Protection Clause. But there are 3 justices who kind of signaled that they think that. And, I think that that's the sort of scary next case. That is, right now, we sitting here, the 4 of us and admissions officers who have much more expertise than we do, will be able to think about other ways to achieve diverse classes that don't involve racial classification. President Biden put out this idea of the adversity index, right? You think about, there are lessons to be learned from the experiences of the University of California system, which have thanks to kind of hundreds of millions of dollars of investment and lots of creative thinking, managed to recruit sort of the most diverse class ever in 2021. You know, asterisks aside from the Berkeley campus, asterisk largely a function of increasing Latinx population in California. But in any case, there's lessons to be learned. There are ways to kind of overcome this opinion as it stands. What makes me nervous is kind of the next frontier in this slate of challenges, which seems to suggest that any consideration of increasing diversity, even if you find a race neutral way to do it, will be subject to litigation.
If I can jump in, I imagine Easha is right about what the next litigation is going to be, but I have a very strong prediction that it's not going to succeed. That there is nothing, there's no hint in the majority opinion that the motive of diversity is an illegitimate motive. It's the focus on race as a classification that the majority opinion is opposed to, and it's the crudeness of and like over inclusiveness and under inclusiveness of race toward getting at some of these underlying factors that is the problem. And as long as the universities and schools are focusing more closely on the underlying reasons, and instead of focusing on race itself, I think they're going to be just fine under the majority opinion. I'm again not that people will bring lawsuits. There's going to be plenty of future litigation. I don't think any of us have to worry about unemployment, but I think people who imagine that this is the death knell of all kinds of efforts that genuinely and focused and tailored efforts to promote either diversity or, let me say, remediation are not. I don't think they understand. I think they're projecting a kind of ideology on the court that I don't think is there. And just to return to the way in which the majority opinion was written, I think there's a lot of comfort there for people who do want tailored methods of achieving some of these legitimate objectives, because the opinion is so focused upon the fact that Harvard and the University of North Carolina, and indeed most prestige universities, are not tailoring their program in any. They don't even pretend to tailor their programs to the supposed to what they claim to be their purposes. But the other side of that is, if they did, that I think the majority opinion would give them a great deal of support. And also, may I just, this is not quite on Easha's point, but earlier I had said that there were 2 points on which I found the dissenters persuasive. One has to do with this endpoint, this idea that there has to be an automatic sunset. The other thing that I think they were right about is they basically depart from Justice Powell's idea in Bakke that the only legitimate use of these techniques is educational diversity, and they are much more focused upon remediation of past discriminatory action. And on that, I think they are 100% right. I've always thought that Powell's opinion in Bakke was barking up the wrong tree. Not that diversity is a bad thing, but that I think most people who support any kind of affirmative action, soft affirmative action or whatever, I think most people are motivated by a sense of remediation of past injustice rather than what goes on in the engineering classroom as a result of more racial mixing. So and on that, I think the majority opinion leaves universities a great deal of running room.
So, thank you for that. So final assessments, we have just a couple of minutes left. Let me just offer each of you a chance to make a closing statement. What's your take home message? Because everyone on this call is going to be asked by somebody, well, what was the take home message? So if you have a take home message you can give people, now is the time to offer it. Let's just go around the screen as I see it. Easha, you would be first, and then Michael, and then Rich.
Well, I don't know if this is the one take home message, but just to pick up on what Michael just said, I think that's exactly right. The dissenters are in some ways laying the groundwork for a different kind of justification for affirmative action. They talk about remedying past discrimination, and we've sort of talked in this conversation about a few ways that might look different from current affirmative action programs. There's also this kind of Justice Ginsburg's Grutter concurrence idea lurking out there, which is you can justify affirmative action as a sort of in a sort of meritocratic way, right? To what Rich said earlier, a Black student who looks identical on paper to a white student likely actually had to perform with much more grit and smarts to have that same on paper record, given the biases that they are facing from the various actors in their lives. And so I suppose I would say, yes, we should talk about ways to structure admissions programs around this opinion. Yes, we should be thinking about, what are the consequences going to be for diversity in the classroom, but also this opinion only addresses the kind of analysis as to one very particular rationale, a rationale that for the reasons Rich and Michael have said was always on shaky ground. And so I hope we don't sort of totally give up the ghost on thinking about other ways to justify race-based affirmative action.
I would just say, and while we're at it, universities would have a lot more credibility when they talk about diversity if they actually cared about diversity and not just about race. There are a lot of other aspects of diversity where modern universities, including our own, are not only don't seem to care, but actually seem rather hostile. And I'm talking now about especially philosophical, ideological, religious diversity. And it's really remarkable how homogeneous elite universities are on those dimensions.
I think it's interesting that there's a lot of agreement about the limitations of the diversity rationale and the need for thinking about the ideals of equal protection in a broader sense. I think my takeaways would be, one, affirmative action could be understood perhaps best on the basis of an older ideal, something that we don't talk as much about today, integration. And the affirmative action is a way to integrate institutions that had historically been segregated in a society that is still very segregated along the lines of race, at the K through 12 level, at the neighborhood level, at the level of religious worship, at the level of many workplaces in places of employment. And so college is often the first time that a lot of people encounter somebody of a minority race. That matters. And the other thing I would say is that we're used to looking to the Supreme Court to give us our not only our interpretation of the Constitution, but our ideals of justice. And that I think is a mistake. I think that today the nation has a sense of the ideals of racial justice that are more expansive than the narrow idea of color blindness articulated by the Supreme Court. And I hope that we hang on to that broader sense of what the possibilities and the necessity of racial justice, and not simply fall back, as we did in the context of diversity, for instance, on whatever the Supreme Court says to kind of limit our notions of what's possible and our notions of social justice.
Some great final words. Thank you so much to the panelists. Thank you to those who arranged the event, and thank you most of all to those of you in attendance. Although this is a case that only comes along once in a generation, these types of conversations are conversations that we want to repeat periodically and to model the best form of intellectual engagement, where we in fact do agree and we don't have homogeneity, and we can be a model for how to disagree agreeably and to probe some of the big challenges in our society. Thank you all. We are signing off now.
Thanks, Rick.
Thank you.